Dear friends, today we will learn about the topic reference, which is envisaged in section 113 CPC and also relatively Article 46 says the procedure regarding reference. First of all, let us know what is reference. Yesterday I told you about the appeal and also second appeal, right from section 91 to 96 I told you. So appeal is a request to the higher court on the order given by the inferior court that some injustice was done or the court has grossly erred. They have not taken into consideration of your so-called arguments or your pleadings. Now, the court itself may get some doubt regarding the validity of an act, the validity of a statute, the validity of an ordinance. Sometimes ordinance will become act. Till they are ordinances, whether they can be approved, whether they have to be taken into consideration or not. Or sometimes they will get a doubt whether the punishment which is envisaged previously and whether punishment which is envisaged now, is it applicable or not. Best example is, of course, it comes under CRPC. Best example is section 354 IPC. Section 354 IPC, when enacted, it is only 2 years punishment. But in 1991, the AP government has given an amendment that since outraging of modesty against women are more in number, the punishment has been enhanced to 5 years. Next came Nirbhaya Act, wherein 354 is divided into 354 A, B, C, D. In that, once again, 3 years have come. So now there is a confusion whether during 2013 there was a confusion whether 5 years punishment should be given or whether 2 years have to be given or 3 years has to be given. In these circumstances, whenever the court entertains a doubt regarding certain matter of law, then they can refer the matter to the higher court, particularly to the high court to get clearance. This is a reference. Even CPC also definitely you may have so many, the court may entertain so many doubts. Of course, whenever in the there should be some conditions. First of all, there must be a suit and the suit must be pending. Secondly, a question of law. Question of law, like conflicting decisions will be there, conflicting opinions are there, double opinions are there. In such a case, which opinion they have to take? Or usage of the face of law. Definitely some doubt should arise. Then, whenever the court entertains a doubt, they cannot directly themselves, if they are competent, okay, they can clear, because the ultimate duty of the court is to interpret the issues. But interpretation is according to Article 228 of the Constitution of India, it rests with the High Court and superior courts, we can let us say Supreme Court also. So whenever any interpretation is needed regarding the Constitution or any act or statute, you have to refer to Article 228. Right. Now, let us know what does section 113 CPC say. It says that any court may refer any question involving validity of an act, whether act is valid or not. For example, if you get a doubt that whether Protection of Civil Rights Act is still in existence or not, you can refer the matter. Of course, it is there. Or Telegraph Wise Unlawful Act, Possession Act 1855, still whether it is there or not, we do not know. So, when our Prime Minister Shri Narendra Modi took charge in 2014, I believe, and he said, I will scrap delete all these age-old laws. But we don't know how many are scrapped or how many deleted, we do not know. So, whenever they get a doubt regarding the validity of an act or validity of an ordinance, yes, ordinances sometimes will become acts. Sometimes ordinance will subside. Some ordinances like the Tada Act, at times the ordinances will subside, they will not take the shape of an act. Or regulations, there are certain regulations or any provision of the act, certain times certain provisions may be deleted. So certain people may get a doubt regarding, the court may entertain a doubt regarding the validity of section 66A of the Information Technology Act. So in a very famous case of Shreya Singhal versus Reign of India, Justice Chalameshwar Rohington Tan, they held section 66A as unconstitutional. So whether the court can apply it or not, It is a doubtful question. So, under such circumstances, definitely they can refer the matter to the High Court, and High Court may make such order as this thing face. That means, please remember, High Court may reply or may not reply, may give opinion or may not give opinion. But normally, as a prudent man, we have to think that High Court will come to the rescue of the lower court, and definitely they will give a clarification. But here, please remember, the consultation with the High Court is only the jurisdictional High Court is only consultative. It's not mandatory. The High Court may answer the question, refer to it, and send back the entire file. It can also refuse to answer the reference or quash it also, because sometimes some silly doubts may be entertained by the court also. In such cases, normally High Court, I have seen a reference being replied by the High Court. Please refer to section 21A of the Act. If you don't know, consult your senior. Like that, they have given a bombarding reply, befitting reply, I can believe. So, in this connection, in the famous case of Krishna Rao Bhaskar versus Lakshman Rao Chandra, 1929, a High Court has refused to answer. Please look to the Act. Please have the so-called literal interpretation. Then only you will get the answer. And in another case, in the case of Municipal Corporation of City versus Shiv Shankar Gauri Shankar, 1998, the High Court stated that it cannot make any order or on the merits, or can it make any suggestions. It is your prerogative, right? Please remember, the High Court normally, definitely in so many cases, they give the reply. But why am I telling you the negative judgments is the High Court need not answer for this. So, if you go to the CRPC, there is a provision for reference also. I think it is section 395 CRPC, where you can ask, just like I told you about 354 IPC, you can refer it there, right? So, this is briefly regarding reference. So, please look to the video twice or thrice, because I am quickly going through the subject, because the subject time is not there for me to complete the syllabus. I am quickly telling in the class, please refer to my, read this or see this video twice or thrice, so that you will be benefited very much. Thank you very much.